Good morning, everybody. Very nice to be here. It would have been even nicer to be in beautiful Prague. Personally, I didn't manage for various reasons. But anyway, thank you for the wonderful presentations we already heard until now. I'll talk about the German case now, and by the same token, I'll in a way talk about my theoretical perspective on freedom and sustainability. Given that I wrote a postdoctoral thesis called Theorie der Nachhaltigkeit, or in the English translation, Sustainability, Transformation, Governance, Ethics, Law, published with Springer Nature, dealing with various issues of human sciences and sustainability, that delivers an overall approach to freedom, human rights, and sustainability. This research was discovered by a small NGO called Solarenergieförderverein, Solar Energy Promotion Association, in 2010, that didn't believe that it would be possible to get political majorities in Europe and Germany to really act on climate in a responsible way. So they wanted to go to court for years. They urged me to prepare a lawsuit together with them. They asked me for various legal expert opinions during the last 10 years. I always tried to stop them in a way because I was pretty convinced of the arguments, but I knew the German tradition in terms of human rights and constitutional complaints, which is a rather classic liberal one. There was literally no constitutional complaint aiming at more environmental protection that was successful until then. But then the Paris Agreement came, new climate data popped up, and so we decided to form a lawsuit alliance in early 2018 with the SFV, Friends of the Earth Germany, BUND, and various single claimants, Josef Göppel, Hannes Jenecke, and others. By the way, I wouldn't call the case Neubauer et al. Because Luisa Neubauer just joined us in 2020. Of course, she's a very well-known, very recognized Fridays for Future activist, but the history of the case has really not much to do with Luisa, admittedly. So we filed the constitutional complaint in November 2018, at a time where even the German environmental NGOs didn't really believe it could be successful. We really tried to form a huge lawsuit alliance, but it wasn't possible because all the NGOs that joined us later, like Greenpeace or Deutsche Umwelthilfe, didn't want to join. They believed it is pointless. And then in August 2019, big surprise happened. We got the acceptance for decision by the Federal Constitutional Court. And this caused a big change of mood in society and politics and also environmental NGOs. So in January 2020, 3 further constitutional complaints were filed inter alia by Luisa Neubauer, Fridays for Future activists, Greenpeace, Deutsche Umwelthilfe, and others. And this spring, we got the verdict from the court that gave us the first successful lawsuit aiming at more environmental protection before the FCC, as mentioned earlier. It's arguably the most far-reaching ruling by a Supreme Court on climate on a worldwide scale. And what is worth mentioning, given the presentations we heard earlier, without any mentioning of a right to a sound environment, or things like that. Eva Schulev-Steindl also presented some aspects of that, but I think I'll have to go a bit more into detail here. My overall idea in advance when we prepared, when I conducted my research and when I prepared the first constitutional complaint in 2018 as an attorney, was liberal democracy is always about balancing different aspects of freedom represented in rights to freedom and rights to the very preconditions of freedom. I mean, elementary preconditions such as life, health, and subsistence, and other norms that in a way also promote our autonomy, such as social policy, etc. And this, in terms of climate change, takes us to a situation where on one hand you see freedom rights of consumers and enterprises, and on the other hand you see the right to the elementary preconditions of freedom of literally everyone in this world. This situation poses what I would like to call a double threat to freedom with regard to climate change. On the one hand, there's the danger that climate change encroaches the vital basis of our freedom. Now, on the other hand, there's a danger that we neglect the problem for a very long time and then try to solve the problem very, very fast. This may also be highly relevant in terms of our freedom. Dealing with climate change is about avoiding both threats to freedom, in my opinion. And for me, it's a new experience that I can talk about a federal constitutional court's ruling now that really adopted some of the ideas that I found right 20 years ago, because I am used to be seen as a kind of pariah among German lawyers, sometimes also among international lawyers, when telling all these strange things. The court statement of the Federal Constitutional Court is not only what Eva mentioned earlier: climate targets must be regulated in the long term, and parliaments, not governments, must make the most important decisions in climate change. What is even more important, the court said this is the case according to the reasoning of the ruling, and the reasoning explains in detail that the balance between intertemporal spheres of freedom must be fair in terms of climate change. And it isn't if we use up all possible remaining emissions in only a couple of years. This is the most important message we got by the Federal Constitutional Court. And this is precisely the scheme that we presented to the court, saying, of course, there is leeway for balancing for the democratic legislature, given that there's the economic freedom of consumers, enterprises, etc. on the one hand, and the right to the very preconditions of freedom on the other hand. But this balancing leeway also has limits, balancing limits that can be derived directly from human rights and also from the state objective to environmental protection that we already heard something about in earlier presentations. The role of the Constitutional Court is not to replace legislation, but to make it clear where balancing limits are violated. And this is what they did in the end. Furthermore, they made some important new points that we proposed. They accepted freedom has an intertemporal and global or extraterritorial dimension. They accepted that freedom rights also contain a kind of precautionary principle, meaning that you don't have to prove that you're affected by climate change here and now. And this is something very, very different from the international debate we have seen on human rights and climate during the last 20 years. In the way they just put aside all the debate on causality, attribution, etc., and said, okay, according to precautionary arguments, literally everyone can go to court and say, I might be affected by climate change, given the drastic consequences in terms of wars on resources, huge migration movements, etc., that may take place in the future. This also means that the court dropped his old idea that human rights claims are only possible in a situation where someone can present some kind of prominent encroachment, like I'm more encroached than anybody else. The court overcame this idea in this ruling, and this is, in my opinion, very, very important also in other areas of the law. What is also quite important, the court clearly accepted we have this right to the elementary preconditions of freedom, to life, health, and subsistence. This is quite important, since the right to subsistence is not literally mentioned in the Constitution. In a way, the court leaves open whether this right really exists, but if you read the ruling carefully, you learn, okay, in the end, they believe there is such a right. With regard to our conference, it's also important to mention the court accepted that the 1.5 degrees Celsius limit has to be read as a 1.5 degrees limit, not as a 2 degrees limit. And it is legally binding, not just some strange kind of political idea, at least under international law and under constitutional law. As Eva mentioned earlier, it's at least constitutional to see this as a normative yardstick for climate policy. This all may sound quite groundbreaking, and there's a lot of global discussion and global reaction to this ruling during the last weeks and months. But nevertheless, the ruling also has some weak points, in my opinion. I just mentioned 3 of them with the 3 big bullet points on this slide you can see now. The first one is the following. We tried to get the court to make a ruling that makes it clear that Germany can reduce its emissions only by acting different also on transnational level, given that climate change is a global challenge, and given that only domestic action is always in danger of just shifting the problem to other countries, and by the same token causing problems in terms of competitiveness, lack of social acceptance, etc. The court didn't deal with that in detail. At least they made it clear in the reasoning that climate change has to be addressed internationally, but they didn't make it precisely clear that most of the emissions are governed by the EU, not by Germany anymore. So the most important question after such a ruling is not what will German governments or German parliamentary majorities will do on a domestic level, but what will they do with regard to the Fit for 55 proposals of the EU commissions. Will they try to water it down? Will they accept it? Or will they try to improve it? And they clearly will have to try to improve it, because the proposals from July 2021 are quite promising, but they're not sufficient to stay within the 1.5 degrees Celsius limit. The second problematic aspect of the ruling is, if I already mentioned it in a way, how the court deals with the double threat to freedom. The court gives the impression the most important danger in terms of climate change is not climate change itself, but neglecting climate change and afterwards being very fast in terms of climate policy. This is, to say the least, a very classic liberal way of dealing with it. Of course, there is this double threat to freedom, but in my opinion, given the danger of wars on resources, etc., the bigger danger is still that the vital basis of our freedom gets violated by not dealing with climate change accurately. This strange result is caused by a special perspective on constitutional law. On the one hand, the court accepts there is this right to the elementary preconditions of freedom, but then they say, okay, due to balance of powers, we cannot go into detail here in the end. This is flawed, and we explained that really in detail. The court didn't deal with that at all. They just repeated what they said for 40 years already. We try to make it clear. This talk about positive and negative obligation is really misleading, because taking the right to health, the life and subsistence to court doesn't mean that you try to make the court say to the legislator, do precisely this. This would be a kind of positive obligation. No, the intention of such a lawsuit is a ruling saying not like this anyway, not do precisely this, but not like this anyway. Constitutional complaints are always about defining limits to democratic leeway, not about defining precise measures the legislator has to put into practice. But the court didn't want to discuss this. So they said, okay, there is this human right, but in the end, we cannot really discuss this. Then they discussed the state objective to environmental protection in detail, and came to the not very surprising result, where a state objective is something quite vague. It might sound nicer than it did in the Austrian ruling, but the result is pretty similar, because they said, okay, we cannot really deal with it because the German climate policy may be completely flawed. They more or less say that in the reasoning, but in the end, there is such a big leeway, so we cannot really say it's unlawful, it's unconstitutional. So they needed this strange move of addressing the danger of climate policy for freedom. In my opinion, this will have to change in further verdicts to come. There will be further constitutional complaints. We'll file one more and other processes on other legal levels as well. The third weak point of the ruling, in my opinion, is the following. The court accepts the 1.5 degrees Celsius limit, and they understood that this takes us to a budget, and they read the IPCC reports very well, but they didn't understand the criticism. And the IPCC, of course, presents only a minimum consensus. And the IPCC makes some very optimistic estimations in terms of empirical issues, for instance, climate sensitivity, and what is more important to a court, in my opinion, they make some problematic legal assumptions. For instance, they seem to see the 1.5 degrees Celsius as something not binding. The court clearly refused to that, but it didn't criticize the IPCC budget, which they would have to do if they think 1.5 degrees Celsius is legally binding, because the IPCC thinks there's the possibility of an overshoot. It thinks there's the possibility of staying within the 1.5 degrees Celsius limit only with a probability of 50 to 67%. But this is flawed given that the target is legally binding, and also an overshoot is unlawful given the wording of the Paris Agreement, which says holding the increase of global temperature below, etc. They don't say you can have an overshoot and afterwards get it back. This is not what the norm says. So there is further need for discussion on what the 1.5 degrees Celsius limit actually means. I think I have to finish my presentation, just 3 or 4 sentences to sum up. What does this all mean on political level? There is a need for more ambitious climate targets. The German Parliament presented more ambitious targets in June, but in my opinion, still insufficient, because we will still consume most of the remaining budgets, even if we take the insufficient IPCC budget in only a couple of years. Furthermore, we will have to discuss European consequences, and as mentioned earlier, in my opinion, the German government is obliged now to try to move forward the EU in terms of an ambitious Fit for 55 package. What is also important, we'll have to discuss policy instruments in the future also as constitutional issues, not only goals. Until now, we only have discussed the level of ambition, but of course, in the end, we need instruments. All of this is also relevant for other levels of statehood. I'll not go into detail here for time reasons. And as my last point for this talk, of course, the results of this ruling highly matter also for other environmental challenges, given that the drivers of the environmental challenges are very often the same. It's fossil fuels, it's livestock farming. If we address these challenges, and we have to after the FCC ruling, this will also enable us to make strong progress in terms of biodiversity protection, closing nitrogen cycles, etc. Thank you for listening.